Good evening. We begin tonight with a legal line drawn in the sand. A federal judge has issued a ruling that does more than just deny a motion, it slams a procedural door shut, and the reverberations are significant. The case is the defamation judgment against Donald Trump brought by E. Jean Carroll. The amount is $83.3 million. And the two words from Judge Alvin Hellerstein are, motion denied. But this denial carries the weight of a closing argument. Here's what happened. After a jury delivered that massive judgment, after an appeals court upheld the core of it, Trump's legal team returned to the trial court with a new filing. They argued that a technicality in the original jury instructions, a point they called newly discovered merited reopening the question of damages. Judge Hellerstein, a seasoned jurist who has presided over some of the most complex cases of our time, received this motion, and on Thursday he issued a 47-page response. It is a methodical, precedent-driven demolition. The core legal principle he invoked is issue preclusion. In plain English, you don't get infinite bites at the apple. A court decides something. That decision stands. You can't keep coming back with repackaged versions of the same argument, hoping for a different outcome. The judge wrote, and I quote from the filing, "This motion seeks precisely what the law forbids." But he went further, specifically targeting the claim of a new discovery. He pointed out that the legal argument Trump's team is now using was available to them during the trial. It was available during the first appeal. They chose not to use it then. Their failure to raise it earlier, the judge ruled, does not magically transform it into a new key to unlock the door. He wrote, "The failure to previously assert an argument does not transform it into a newly discovered basis for relief." This is where the ruling transcends this single case. Judge Hellerstein didn't just look backward, he looked forward. In a notable passage, he addressed future conduct, stating that any further motions based on substantially similar arguments would face summary denial. He called a halt to what he termed indefinite procedural cycling. He is not just ruling on a motion, he is setting a boundary for his courtroom. Now, let's be clear on the counterargument, because it exists. Trump's team contends this is about due process, that a footnote in an appeals court ruling opened a fresh avenue. They have filed a notice to appeal this denial, as is their right. Some legal commentators note the motion was a technically permissible, if long-shot legal maneuver. But the consensus among seasoned litigation experts is clear. Overcoming this denial on appeal is a monumental task. The standard is abuse of discretion, proving the judge acted so unreasonably it was an injustice. With a ruling this thoroughly grounded in legal doctrine and procedure, that is a steep, steep climb. So, what are the practical, right-now consequences? First, the $83.3 million judgment remains fully intact. This procedural challenge failed to touch it. Second, the path for future delay tactics in Judge Hellerstein's court has been dramatically narrowed. He has put up a do not enter sign. Third, and most immediate, the focus now violently pivots to collection. E. Jean Carroll's legal team has signaled their intent to move swiftly to enforce the judgment. The looming question is whether they can begin that process while an appeal of this denial is pending, or if Trump will be required to post a bond for the full amount to pause it. This is where the law meets the ledger. The legal arguments about procedure are, for the moment, exhausted in this venue. What remains is the financial enforcement of a judgment that has now been affirmed and protected at multiple levels. This ruling is a case study in the principle of finality. A court system cannot function if verdicts are merely suggestions, subject to endless review on the same grounds. Judge Hellerstein's message was that, for this case, in his court, the time for retreads is over. The record is closed. The judgment stands. We will, of course, continue to track every development, the appeals, the collection motions, the financial maneuvers, because this story is now entering a new and decisive phase. Thank you for watching.